Greetings, everyone. The following is a short presentation of the basic documents required in a Colorado estate plan packet. For a brief introduction, my name is Amos Luke Soignier, and I am an attorney with the Soignier Law Firm. I have been practicing law in Durango, Colorado for approximately 17 years, and I've been specializing in elder law and estate planning for that time. In Colorado, there are 4 basic documents that everyone needs in their estate plan. Those documents include a medical power of attorney, a general financial and legal power of attorney, a living will with advanced medical directives, and a last will and testament. I will go over each one of these forms and what they do and why you want them in your estate packet here. Let's start with the medical durable power of attorney form. In Colorado, if you're over 18 years of age, you can name individuals to make medical decisions for you in the event you're unable to make those medical decisions yourself. As when you create this form, you are called a principal, and the people you name to make decisions for you are called agents. You can name co-agents, that is to say, more than one person with the ability to make medical decisions for you. And you can also name successor agents, where you create an orderly succession. In the event the first person you name is unable to continue on, you can name someone to step in and make medical decisions for you in the event you're unable to do so yourself. When you name a medical agent to make decisions for you, that person can make medical decisions. Those decisions can include the right to receive treatment or to refuse treatment. It also can involve your placement. They can help assist you in hiring people to come and help care for you in your home or set you up on hospice if the circumstances warrant. They can also assist you in being placed into a facility in the event you can no longer safely remain in your home. Your medical healthcare provider can also assist you with daily hygiene and health activities to make sure that you maintain a safe and healthy routine in your daily life. And then last, your medical agent is what's called a HIPAA, Healthcare Privacy Act personal representative. That person can receive your medical information, can communicate with your doctors and treatment providers, and share that medical information to make sure that you have appropriate treatment. When a person does agree to be someone's medical agent, they are not taking responsibility for the person's medical treatment expenses. An agent is not responsible for the principal's medical treatment costs. Likewise, an agent can be reimbursed or compensated for any out-of-pocket expenses the agent incurs while acting as a healthcare agent, and, if the form allows, may also collect a small, reasonable wage when acting as someone's agent. Other issues you always want to address in your medical power of attorney form is nominating a guardian in the event that a guardian has to be appointed for you by a court of law. You also want to make sure that you revoke all prior medical powers of attorney so that they're not competing forms out there with multiple people having authority to make decisions for you. Sometimes you can give your medical agent the ability to override your wishes in a living will as to when you would like life-sustaining support to be discontinued. And then if there's any special treatment or issues, you can always address those in your medical power of attorney form to let your agent know what type of medical decisions you would like them to make. Now, moving on to the general power of attorney form, we will address that Colorado allows individuals 18 and over to create a general power of attorney that nominates individuals to make decisions for you in the event you're unable to make financial and legal decisions for yourself. In Colorado, when you name an agent, you can also name co-agents or successor agents depending on the circumstance. If you would like more than one person to be responsible for making legal and financial decisions for you, then you can designate co-agents on the form. You can also set up successor agents to take over and assume the job in the event the first individual you name is no longer able to act as your power of attorney. In Colorado, when you grant someone to act as your legal and financial power of attorney, there are general grants of authority that you give them in the document, and there are also specific grants of authority that you give them in the document. The general grant basically stands for the proposition that your agent can do anything legally and financially that you can do yourself. Examples of this is to access your checking account to pay bills or to put money into it, access your other financial assets to make sure that you have enough money to pay your bills and meet your responsibilities. They can also sell or acquire personal property. They can sell or acquire real property. They can also sign contracts and enter into legally binding agreements on your behalf. They can sue people on your behalf. They can also seek to release people or give releases for you on your behalf. And here are some examples of specific powers you can grant your agent in your durable power of attorney form. It's important to remember that your principal must initial these powers in order to give the agent the ability to take these actions. And here's a list of some of the examples of specific powers that Colorado requires principals to initial. That's the power to amend, revoke, create, or defund a trust, the power to make gifts, the power to change beneficiary designations, both on behalf of the principal or on behalf of the principal's designation of third parties as beneficiaries. You can also designate your agent as someone able to act as a member of your LLC or as a partner in a partnership agreement. And then you can always give your agent the ability to deal with mineral interests, with to sell, acquire, or to lease mineral interests to gas companies in the form. And then lastly, the principal can give the agent the ability to delegate the agent's powers to third parties. In the event the agent's unable to act, they can name someone to step in their place and delegate their ability to act to that person on behalf of the principal. Again, all of this is only in the event the principal is unable to do these actions himself. Other miscellaneous issues raised when dealing with general durable powers of attorney is you want to make sure you nominate a conservator in the form in the event that you have to go to court and have a conservator appointed for you. The judge will use your nominations as a priority for a list of conservator people to appoint if you have a designation in the form that these names are to be considered as your conservator. You also want to make sure that you revoke all prior powers of attorney forms that you've ever done so that you don't have competing forms out there with more than one people having the authority to make decisions for you. You can always amend and revoke your power of attorney form and change it to someone if you feel that the person you named is no longer able or you no longer feel confident with that person making decisions for you. And then you can always limit your grant of authority in a durable power of attorney form. You can basically identify any specific issue that you would like your agent to address and limit the authority to just that issue when giving a grant of power. It's important that you have an attorney work with you when doing a limited grant to make sure that you word it correctly. And it's also very important to understand when you agree to act as someone's agent under a power of attorney form, you're not taking personal responsibility for the principal's bills. So if you sign a contract on behalf of your principal as an agent, you're not agreeing to be responsible for what the cost of the contract or any payments that are due under the contract. When acting as an agent, you are entitled to reasonable compensation, so you can keep track of your time and submit a small bill to the principal to be reimbursed for your time. And then, of course, you can get reimbursement for your out-of-pocket expenses that you incur in the process of acting as a power of attorney. And last, when agreeing to be someone's agent under a power of attorney form, it's important to know that you're agreeing to be a fiduciary of that person. That's a fancy legal term for you have special duties that you owe your principal. You have to be truthful. You have to have a duty of care. You have a duty of loyalty. You have a duty of obedience. You have a duty to account for your actions and provide supporting documentation and receipts for what you spent. Basically, when acting as someone's agent, you have to put their interests, their best interests, ahead of your own, and you have to use their property for their benefit. You can't personally benefit or self-deal without some special instructions allowing you to do so. And even then, it's never a good idea when acting as a power of attorney to self-deal or benefit yourself with the principal's assets. Now, let's move on and talk about a living will, also referred to as advanced medical directives and a pull-the-plug document. In Colorado, you're allowed to put together advanced medical directives authorizing doctors to discontinue life support if you're being kept alive on the machines and you're otherwise either in a persistent vegetative state or unresponsive or comatose. You must be competent, over 18 years of age, in order to do this form. The form also talks about the situation where you're just in a persistent vegetative state. That is to say, two doctors certify that you've been either comatose, non-responsive, or vegetative for a period of X number of days, after which time you authorize the doctor to discontinue the life support and/or the feeding tube at that time. Now, let's move on to our last form, a last will and testament. In Colorado, everyone should have a last will and testament that sets forth how they would like their property to be distributed after their death. In order to make a will in Colorado, there are 6 basic requirements that everyone must meet. First, you must be at least 18 years of age, and secondly, you must be of sound mind. I will get into more detail what sound mind is meaning in the state of Colorado. In order for your will to be valid, it must be in writing and it must be signed by the testator or a person that the testator said to sign for them if they're unable to sign themselves. And then when signing, that signature must be voluntary. It cannot be the product of any undue influence, coercion, or duress, and must be the free and voluntary act of the testator. If you have that action signed in front of 2 witnesses, then you can submit your will to a Colorado probate court for an informal probate process. The first element of being at least 18 years of age is simple enough. A minor cannot create a will in the state of Colorado except if that minor has a conservator, a court-appointed conservator, that can have the will approved through the conservatorship proceeding by a judge. Otherwise, you have to be at least 18 years of age in order to create a will in the state of Colorado. In order for the will to be valid, it must be in writing. You cannot orally declare a will and have it be enforced by a court of law. Obviously enough, it would be really difficult to determine what was the most recent oral statement by a decedent if we allowed oral wills to be taken into court. A will must be in writing. It can be typed or it can be in handwriting, but it must at least be in writing in order to be a valid will in the state of Colorado. And that document must be signed by the testator or signed by someone the testator instructed to sign for them if the testator is unable to sign for themselves. But in order for a written will to be accepted into a court for probate, it has to be signed. It's not good enough to meet with an attorney, have a will drafted, and then take that unsigned will into court and have that document probated. And when that person signs his will, he must be of sound mind. We also use the term testamentary capacity. In Colorado, in order for a person to have testamentary capacity, they basically need to understand the nature and extent of their property. They also need to understand who their heirs are at law and who they are morally obligated to support in this process. Furthermore, when they sign the document, that signature must be a free and voluntary act on behalf of the person creating the will. That signature cannot be the result of any misunderstanding or fraud or duress, coercion, undue influence, or anything that would make that person sign that will against their free and voluntary act. And the last requirement to have a valid will is it must be witnessed by two people. These two witnesses need to be independent witnesses. They shouldn't be heirs or have any financial benefit from the decedent's estate. They need to sign their names, and it's a good idea to have them attest to the fact that they're signing as witnesses because they saw the testator sign, and in their opinion, the testator was of 18 years of age, of sound mind, and under no undue influence, coercion, or duress when they sign their trust and will. If you have two witnesses attest to those facts, you can take a signed will into a probate court and proceed with an informal probate proceeding and have the will admitted and a personal representative appointed without any hearings or formalities. Without a self-proving affidavit signed by the witnesses, in the event that the will is needed to be probated, you will need to call a witness into court to testify as to the validity of the will and his observation of the testator signing the document in order for that will to be admitted. If you have the self-proving affidavit, you can avoid that procedure and simply have your will admitted to an informal probate. There is one exception to the two witness requirements in Colorado, and that is when someone provides a handwritten will to the probate court. The probate court will accept a handwritten will provided that the entire will is in the handwriting of the decedent. If it is signed and dated, a probate clerk will accept that and open a probate based on that document, and it does not need to be witnessed. So this concludes my very brief summary explanation as to the 4 basic documents required in every estate plan in Colorado. I thank you sincerely for your attention to this presentation and your interest in the subject matter. On this card is my contact information. Please feel free to contact me if you have any questions or would like additional information about any of these forms or anything else related to Colorado estate planning. Thank you, and I wish you the best.